Good afternoon, everybody. Thank you for joining us on this afternoon's webinar, Medical Malpractice, Insights for Plaintiff Attorneys. My name is Paul Myers. I am the Chairman and CEO of Advocate Capital. All we do every day is help plaintiff law firms get even better results for their clients. So we're glad you could join us. Hope you find this interesting and educational. Couple of technical notes. Number one, as we go through this today with Katie, please feel free to ask questions. There's a chat box or question section in your webinar app. You could type them in there and I'll relay the questions to Katie. Secondly, if you don't catch everything or if you want to take another look at this, we will edit this and have it ready to be a link to be emailed to all of our registrants. So you'll have an opportunity to see it again. So with that, we'll get started. There she is. Hey, Katie. Thank you for joining us. I'm going to read a little bit about Katie real quick. So Catherine Bertram started the law firm Bertram Murphy, building on decades of experience as both a medical malpractice attorney and director of risk management at Georgetown University Hospital. In those environments, she learned how doctors and hospitals work, as well as how their attorneys assess claims against them. She draws on this knowledge to advocate for patients and their families. She's achieved many significant verdicts and settlements for patients and their families in DC, Virginia, and Maryland over the past 3 years, including a $17.1 million verdict in DC in 2022 and a $12 million and $35.6 million verdict in 2019. The vast majority of her cases settled. Her goal for each case is to obtain full and fair compensation for her clients. Katie has obtained settlements totaling over $75 million for her clients and their families over the past 5 years. Katie's unusual background gives her the ability to look at cases from a 360-degree angle. She was formerly the director of risk management at Georgetown Hospital. As a result, she has extensive experience in why errors occur and how they should have been prevented. So with that, Katie, welcome. Thank you for joining us.
Thank you, Paul. I'm happy to be here. Thank you for giving me this opportunity to talk about my favorite subject.
Well, great. Well, before we get going, I did want to just point out, quick disclaimer, this has been prepared really for informational purposes only, not intended to provide nor should it be relied upon for tax, legal, accounting advice. If you have questions about that, you should, of course, consult your own tax, legal, and or accounting advisors before taking any action. So Katie, thrilled to have you. I know that you are a expert in med mal litigation. We're thrilled to have you as a client, thrilled to have you today to join us. And with that, I guess we'll just jump in. We're going to have a little question and answer back and forth and let Katie hopefully give our viewers some information they may not have already had, or at least reinforce some of the things they knew. So Katie, I guess to begin with, when you have a med mal case you're looking at, how do you decide if it's really negligence or malpractice, or if it's just an accepted complication?
So that's a two-stage process, really. The first stage is to have somebody that you trust doing the initial intake. So either a lawyer, or in our firm, we have a nurse that actually calls to do the intakes, and she's been doing nursing paralegal work for over 25 years. So she's really good at asking the right questions. And that's what you need, because as your question asks, some things that go wrong can be called accepted complications, meaning the doctor may not do anything wrong, yet there's a bad outcome, right? But the analysis doesn't stop there. And the example I will give is something, none of us want to get, but let's say you go in for a colonoscopy. Well, you could have a perforation of your colon during the colonoscopy. That is not necessarily negligence. That can happen even when the doctor is using due care. But you have to know the next questions to ask, and that is, how fast was it identified? What was done when you started having those symptoms? Did you need the colonoscopy? So you need to have somebody who knows, the areas of medical malpractice and the areas involved in that person's care to really ask the right questions to get down to that answer. Was it negligence or just a complication that can happen?
Okay, that's Really good information. And you're right, having that, I guess, knowledgeable individual on the intake has got to be key, because identifying those issues on the front end early on, I think could tell you and your client, potential client, whether or not there's a real case to be made.
Right, and here's what you learn pretty fast if you've done this for a while. You get probably 80 to 90% of the calls are not medical malpractice.
Right.
It's very sad, but a lot of people have complications or things go wrong because of their medical conditions, and they're tragic, but they're not medical malpractice. So as lawyers, we have a duty to these citizens to make sure we're telling them whether they have a case or not. But also, as a business person, you want to run your law firm so that you spend your time and your staff's time working on cases that have merit. So the faster you can decide that in a correct way, the better off the citizen is and the better off your law firm is.
Agreed. All good points. Now, as you're going through this process, I know that there are patient rights. That's an important topic, to know what patients should expect from their physician or healthcare provider. What patient rights do you see that often go unrealized that are protected under medical law in your state?
So I think, and you said the end of your sentence was very important, your question. It's all about the state. So different states have set up rights for patients in a different way. So you need to be careful, because informed consent can be different things in different locations. Or lots of patients, everybody is supposed to have access to their records under HIPAA, which is a national law. And you're supposed to be able to obtain your records in 30 days. There's a lot of laws that you have to know about, and a lot of local regulations about how long they have to maintain your records and how much they can charge for your records. But also, what are you entitled to know? How much information are you entitled to know when you are going in for a procedure? That's what we call informed consent. What do you need to be told? And different states have different laws about the nature and extent of that conversation and how detailed the doctor has to be or the practitioner has to be. For example, in DC, they actually have to tell you the recognized risks, the standard risks that may be a small risk but could happen a lot, or the devastating risks that are rare. And the standard that we apply is what would a reasonable patient want to know. So that's quite different than some other jurisdictions. So you need to know what your law is.
Okay, excellent. Well, thank you. And then kind of, I guess, this harkens back a little bit to our initial discussion about identifying the case, because like you said, it does neither your client nor the law firm any good if you bring a case that really doesn't have any merit. So how do you identify a strong med mal case, and what does that claims process look like when you're building that case?
So after our nurse does the initial intake, my partner and I look at every intake, and then we decide, is this worth looking some more? Is it worth talking to the family about? And then we have a meeting or a call with the family. You can't really decide if most cases are real until you get the medical records, and in some cases the imaging, and in other cases you need the pathology report if it's a cancer case. And in a case with a birth injury, you also need the fetal monitoring strips. So we talk to the family, we explain what we're going to get, and then we have to get those records. And once we get those records, 90% of the time, the first question we try to ask is, was there an error? Was there a breach in the standard of care? Okay, and that's where we look first, generally. There are certain cases like a delay in the diagnosis of cancer. If you have one of those cases, we actually start with the second question, which is, did the delay cause harm? Okay, and so we look at cause. Was the delay long enough to cause a significant loss to the patient in their chance of survival or in what they needed to have done to recover from the cancer? So in cancer cases, we actually start with the oncology question. But in most cases, we start with the first question, which is, did the doctor or did the system breach the standard of care? So to find that out, sometimes, because I've been doing it for 35 years and I have a nurse and I have a doctor on retainer, so sometimes we can determine that internally, which is great. But most of the time we have to have an outside expert. We retain an outside expert and we have them look at the records and the imaging, and then we have another call with them to determine if it's a case. And I prefer to use actual experts that are willing to testify at trial for that part, because I want them to stand behind their opinion. Some people, you'll see a lot of advertising for people that'll just do a merit review for you, like a confidential review. And the problem with those I worry about is, are they giving you a true opinion that'll stand up in court? So I prefer to invest in a real expert that'll testify at trial, because I feel like if he or she is going to stand behind the opinion, it's much more valid. So it may cost a little more, but in the long run, it saves money, because if you use these confidential consulting experts, you still have to get the other expert to go forward with the case. So for me, I just get the real expert at first and make sure that we have a real case. So when I teach law school, I say it's like a three-legged stool. You've got to have a breach in the standard of care. The provider did something that they shouldn't have, or failed to do something that they should have. That breach has to cause permanent injury. All three things have to be present for you to have a valid case.
Right. And yeah, that kind of a very smart attorney that we did business with in Dallas one time told me, this is not necessarily med mal, but it's just in general. And it's one of these things where I think the notion of a frivolous lawsuit is kind of overblown in our world today, because attorneys who consistently bring frivolous lawsuits are not going to be around very long. They're going to be out of business. But three things have to be there. You have to have an injured party. You have to have somebody that you can reasonably prove was responsible for that injury, and that responsible party has to be able to pay. If any one of those three of that, once again, three-legged stool are not there, it's probably not a case worth pursuing.
That's exactly right. And sometimes that last prong that you just described can be troublesome, because nowadays in some locations, in some states, the healthcare providers are not required to have professional liability insurance. So you can really get yourself into a situation where there was a terrible harm done, but the person has no ability to pay. So you do have to really investigate all those aspects. That's right.
And I would think that would be a very difficult conversation to have with a potential client, is that, yes, you are really, irrevocably, you're harmed in a very bad way. And yes, we can prove that this individual was responsible for that, but all of that doesn't matter, because financially they don't have an ability to do anything to make it right for you. So we could drive them into bankruptcy, but nobody wins there.
Yeah, we just had a case that we got a verdict in February in Prince George's County in Maryland, and we had that situation where the doctor, he was actually fraudulently doing unnecessary procedures on people, and the Board of Physicians actually suspended his license. And so he couldn't practice, and he didn't have insurance, and we only found that out right, 3/4 of the way through the case. And at that point, my co-counsel and I decided it was such an important case that we would go forward for her, and we would go to trial for her. But we did tell her the verdict might be worth about what this piece of paper is worth, trying to sell it on the street. So, but as it turned out, we were able to get a verdict for fraud, which is different from a regular negligence verdict, and believe that we'll be able to collect because of his assets. So we're hopeful.
Well, good. As you're going through building a case, are there inquiries that you should stay away from, that you should avoid?
Kinds of cases, you mean?
No, just I guess. Well, I suppose so. Yeah.
So I think we're a little bit out from COVID, but I think people had very different reactions to whether they would take cases about like failure to treat someone for COVID. Was that something, that you felt was negligence? Around here, around DC, Maryland, Virginia, we didn't take those cases because there were a lot of laws enacted to protect doctors and healthcare providers because it was a pandemic. So I think situations like that, you have to be very, very careful of.
Okay.
I have done some cases involving incarcerated individuals and negligence in that situation, but those are, for example, a completely different thing to do. You have to really know those regulations and how those standards work, because there are standards for healthcare in prisons, so you have to be very careful. Same with the military. It used to be that active military could not sue if they were victims of malpractice. Now they can bring claims, but it's more of an administrative claim. So again, there's a lot of traps and pitfalls, so you have to be careful. I'm glad that the active military has something, but I think it's actually terrible that they don't have the same rights as the rest of us, given that the service they do to this country. And
Right.
so I wish that that law would be changed so that they could pursue claims just like the rest of us.
Yeah, I agree. Okay, as you're, I'm sure that, every type of law has challenges. Tell me some of the challenges that you have learned to prepare for as you're bringing a med mal case.
So this is strange, but one of the hardest things in a med mal case is to actually get the medical records, all of them at once. It's just, they never produce everything they have. And I don't think it's on purpose. I think it's just sloppy, but that can be quite challenging. So you do have to have staff that's very trained in doing a gap analysis to figure out what's missing because
Right.
it can take many phone calls and many emails to get everything that you need. I would say this is a challenge both for the care providers as well as the lawyers. The electronic medical record is a nightmare. It's a nightmare for providers and it's a nightmare for lawyers trying to analyze what happened. So one of the really important things, and we're lucky because our laws recently have changed where I practice, and they've included what's called an audit trail in the definition of medical records. So now the providers have to give you an audit trail. And what an audit trail is basically the back door, the metadata in the electronic medical record that says who looked at what, who changed something, all those things that you need to know. So you really need that tool, you need that audit trail to make sure you understand who knew what when. And I'm going to give you kind of an interesting example. Let's say that your doctor is seeing you for, I don't know, you have a fever in the emergency room and you have a fever and your white blood count's kind of high and they're a little worried, right? When they go over and they enter that data and they'll see your fever, your heart rate, and your white blood count. Most electronic medical systems have built in a warning system. So they'll get a pop-up that's called best practices, and that will say, watch out, this person could have sepsis. Okay, sepsis is very dangerous. It's not just a little infection that could kill you. And they have to click yes or no, and they have to click certain things. Well, that pop-up does not appear when you and I ask for a medical record. So you need to have the audit trail to know what best practices popped up that provider had to click through, right? So that could really, really help you prove your case, but you might not know that if you don't know how to get the audit trail. So all those things become extremely important. In the case we just tried, that doctor, after we sent our request for medical records, 3 days later, they began a massive overhaul, I'm gonna say to be nice, of their medical record. They changed a lot of things in the record. And so when we got the audit trail, we could prove at trial exactly what was changed and when it was changed. Wow. So that's incredibly important to the case. So those are examples. You may also need to know, let's say it's the middle of the night and you need a neurosurgeon to look at a brain scan. When that neurosurgeon, when he or she dials in from home into the hospital record, there's a record of that. There's a record of exactly each image that they looked at and how long they were in there. You need to know that. So it's things like that that you can really get additional details, like almost a fingerprint, right? So, I mean, those are really important.
Yeah, I would think the audit trail would also be helpful in what you call the gap analysis. As far as, all right, somebody changed something, we don't even have that report or yes. That piece of data.
Yes. And when they tell you drafts aren't available, that's not true, right? It's just like our computer. The draft doesn't go away. You think you've deleted it. You think you've put it in that little trash can. But, you
Right.
know, some smart tech person can find it again.
Oh, yeah.
So, you know, I think also we all immediately, I think, unless you're trained, think about the human error, the error by the provider. But really, in 90% of these cases, if you do what's called back chaining and ask why did this happen, what you'll figure out is there's some system error. And that's my risk management background, that I know to say, this doctor came to work to do a good job that day. He or she had every intention of helping this patient. What is it about this system that didn't keep the doctor safe and the patient safe? And usually you can identify something that should have been in place to make sure this didn't happen, because it takes at least 3 human errors generally for it to cause harm in a patient. So, you know, you really need to back up and ask why and what was happening before this happened that they could have prevented. And that's really important.
Interesting. Kind of, again, you talked about the specialists that you have on staff and the way you go about, I guess, initial screening. What other tool sets have you built and networks that kind of overcome the challenges that you talked about?
So I think spending a fair amount of time understanding audit trails is really important, because you're going to get a lot of information through that. And if you're not an expert in it, it's okay. There are actually people you can hire that are audit trail experts, that are hospital systems experts that can really teach you. And if you do that in 1 or 2 cases, you'll become really good at it. So those are good options. I think also knowing what specialty you need, what specialty experts that you need to help you with the case is really important. And I think those of us who have done it for as long as I have what I call Renaissance experts, those who know not only their specialty, but everything in every specialty around them. And they're not going to necessarily testify about all those things, but that's the person you want to start with and really noodle the case with, so that you can understand all the aspects and what other experts you might need, what the literature says. You know, you need that type of expert in most of these cases to help you make sure you've covered all the elements that you need to cover, both to prove your case and to defend whatever the defense is going to throw at you to try to win the case. So you definitely need trusted experts who will spend the time with you to make sure that you're crafting the best case possible.
Excellent. Good points. And then as you get into a case, of course, the hospitals and or the healthcare provider, they're going to have defense counsel. So what are some of the common defenses that you've seen in med-mal cases, and how do you overcome those defenses?
So one of the ones that's the hardest, I think, for victims of malpractice and for other lawyers who might refer cases to understand is, unless it's a birth injury case, all the patients who are involved, who are victims, they came into healthcare situation or hospital because they had underlying medical conditions.
Right.
Some of them have lots of medical conditions. And so you really have to take a hard look at what was the patient's status, what was their life expectancy before they had this terrible thing happen to them. Because sometimes their underlying conditions, or what we call comorbidities,
Okay.
are such that you're going to have a really difficult time proving that the injury would not have happened but for the mistake. And one example, which is sad but true, is if they are a diabetic and they've been a diabetic for a long time and they're not well controlled, those poor patients have some really bad circulatory problems. And so if it's a case where you get a call and maybe they lost their foot, they got an amputation from an infection, you can't just automatically say that's horrible and that was negligence, because if they're an uncontrolled diabetic, that's going to happen to them, sadly. And so you really need to make sure that those underlying conditions are not going to provide a solid defense that you can't beat when you go forward. And so that's really it. There's something we've all heard about, that pancreatic cancer, okay? That's a terrible cancer. It's really terrible. We don't have a cure for it. And because it's silent, it's a silent killer. People don't have a lot of symptoms. By the time they get diagnosed with it, it's too late. It's too late. And so if you get somebody calling about one of those and saying, I had stomach pain 6 months before, that's one where you don't want to spend a lot of money. You want to go right to an oncologist and say, is there a case here? If it had been diagnosed 6 months earlier, would this have changed the outcome? And unfortunately, the answer is usually no. And that's the hardest conversation to have with that family. It's really hard. So, let me see what else. They'll blame it. That's really, and this sounds mean to you, but you also have to watch out. So jurors are just regular human beings. They come into these trials with their regular biases and thoughts about everybody. And so you do have to watch out for if your victim is a lifetime smoker, if your victim is very, very overweight. You have to be very careful with those cases because jurors will sometimes, unfortunately, not on purpose, but will kind of blame the patient. And some of those cases you can't win. So you do have to be very careful. I'm not saying you shouldn't take them for sure, but you really have to be careful on those.
Yeah, and I would think that the defense probably knows a lot of those issues and therefore would be much less willing to settle.
Oh, yes. Oh, yes.
They would be like, all right, let's just take this one to a jury and see what they think.
Yeah, just like we all have our arsenal of things that we like to pursue, they're ready with the 3 defenses that'll, stick. So yes, absolutely. But those are tricky because they might not even be a direct defense. It's just a subtle sort of passive aggressive defense that'll kill you. So you do have to know.
Yeah.
You do have to watch out for that. I mean, focus groups will tell you those, but that's a little late. So.
Right. All right. Tell us a little bit. These are kind of real world examples. Give us some of unique cases that you've been involved with that you've won where you've learned a lot.
So 2 recent ones, well, 3 really, but 2 come to mind. I talked about that fraud case a little bit, and that we learned a lot in, but people won't probably do those too much. But I would say the last 2 big cases I had before that, one of them was the $17 million verdict. And in that case, we really, really started to develop what I consider to be the current standard for informed consent. And that is what is required of a healthcare provider when they talk to a patient and the patient consents to the treatment plan. And, it used to be, if you were 100 years ago, we wouldn't be discussing this, right? The doctor would say, this is what you do, and we would all just have to say yes, right? I mean, you wouldn't get a choice, right? And then slowly it developed, and the doctor was required to tell you risks and benefits, right? And that was it. Whatever they thought, whatever he or she thought, that's what they had to tell you. But at least they had to tell you, right? Well, now, if you're involved in healthcare at all, you know that it's much more involved. It's actually an ongoing relationship between the patient and the provider, and they call it shared decision making. That's a huge step forward. It's a huge important step for our health, but it's also really different under the law. So when you have a case that involves a consent issue and whether a patient would have wanted an alternative procedure or treatment, or maybe didn't even get told and then, got harmed in some way, you really have to develop this whole shared decision-making theory. And, that's my passion because medicine is so complex and it's so siloed now that, unless we are given that information, it is impossible to advocate for ourselves and to make good decisions about your healthcare. So this is vital. And it's something that in these cases, you have to know, and you have to start from the beginning to ask those questions of the providers in deposition and to develop that theory and that line. And it's very, very important. And jurors expect it. They will tell you in a focus group, my body, my right. I get to decide. And so it's super powerful. And I think it's really an important direction for us all to go in for our clients.
Excellent.
The last thing I would say, and this is an area that everybody should be on the lookout for, is cases against ambulatory surgery centers. It used to be that we would all need, if we needed surgery, even if you just needed like a little surgery on your knee and you were going to go home, it used to be that we all would go to the hospital to have those surgeries. But they then started developing standalone surgery centers where you could go. Now, you can't go there for a heart transplant, but you can go there for minor surgery. And it's actually can be more efficient. It can be safer because it's not a place with a lot of infection, right? And they can do a better job sometimes if they do a lot of those surgeries and they're really good at it. So they can be a good, ambulatory surgery centers can be a good thing. But they can also be a problem because they're owned, a lot of them are owned by equity companies because they're very profitable. And so when somebody who's not a healthcare provider is making policy and directing how things go at a facility, they're not necessarily thinking about patient safety first, right?
Right.
They might be thinking about profit. They might be thinking about volume. They might be thinking about billing. So those cases, unfortunately, are going to be, I think, cases that we're going to see more and more. And I'm starting to develop a real expertise in those. So something to be looking out for. I'm not saying you all shouldn't have your surgery at a surgery center, but you need to be careful.
Yeah, I have a lot of friends. I'm in Nashville, Tennessee, and as you might know, it's basically the for-profit healthcare capital of the U.S. with HCA and Lord knows how many surgical center companies and private equity firms and all of that kind of stuff centered solely on for-profit healthcare. So I have a lot of friends who work in that industry, and some of the things that they tell me, but what they're and I listen to them, and very few of them talk about quality of care.
Right.
they're
Right.
talking about it. I don't know if it's assumed that there's a quality of care, but from a business perspective, they're talking about profits and efficiencies and you know, and my daughter, when she was younger, played soccer. She had 2 different knee surgeries as a result of some injuries, and everything went well with them, but she had them both in those ambulatory surgical centers. And I remember the second one she had, I was chatting with the ortho when they finished, and I said, how many of these you do a day? He said, about 20. And I mean, it's an ACL tear, and he just does 20 of them. And they roll them in, which leg, show me the picture, and off he goes. And
which might be fine. Might be fine.
Exactly. I mean, and again, my daughter had no complications. Everything ended up fine. She had the second surgery because she re-injured. It wasn't a faulty surgery, but it kind of blew my mind that physician sat there for 10, 11 hours in a day and did 15 or 20 of these procedures over and over and over.
Right. And which one do you want to be, number 1 or number 19?
Well, I did want to be number 1, and luckily my daughter was the first one. And my wife works in healthcare at Vanderbilt Hospital, and so she said, if we're going to one of those things, I only want to do it if we're 7 a.m.
Yep, that's right.
We'll get there at 5:30 whenever we have to get there, but we want to be the first one that doctor sees.
So that's important. And I think also sometimes the physicians, not always, but if the physicians are have any kind of equity in the ambulatory surgery center, they can steer patients to the surgery center because they can get 2 payments, right?
Yep.
They get payment as the surgery, and if they own the surgery center, they get the facility fee too.
Right.
Whereas if they go to the hospital, they only get the surgery. So they're supposed to disclose that to you. It's like an antitrust issue, and each state has laws about that. So that's something to really look at too. Yeah. And there was just an article, I think it was 2 days ago, published about, so sometimes surgeons, and this is really an anesthesia issue too, have overlapping surgeries, right? So they start on one patient and they let somebody else finish, and they go into the other room and start on the other patient, but they're technically the attending in both surgeries. So that's another thing that's unfortunately coming to a head.
Wow.
So there's lots of things that you have to know to look out for in these cases.
Yeah. Other risks, and I've heard of this many times, understaffing. Again, this sometimes goes back to business issues taking precedent over over patient care issues, or it can just be it's hard to find good people. But how commonly do you see understaffing as an issue in connection with med mal or negligence cases?
I think understaffing is a big issue and has become more dangerous after COVID, because it's hard to get providers. Some providers are burned out. There are less facilities available in some types of specialties, and so it really is a huge issue that's a safety issue for facilities and for patients. You definitely have to look at that issue, and in every case you have to ask, what was the census? How's the average? Was it higher than average? Did you have agency staff working? Because agency staff can be good or they can be not trained. I mean, you just don't know. So you need to look at all those issues, absolutely. And then communication. So if you're understaffed and you're not communicating, that kind of adds a whole nother red flag in terms of safety for patients. So that's another thing. We see a lot of these cases are a result of failure to communicate or miscommunication.
Okay. And kind of as a follow-on to that, are there special tools that you use if you feel like that understaffing was a critical factor in a med mal case? Are there special tools that you can use to kind of drive that home?
Yeah, so you can look at scheduling, you can look at census. Believe it or not, in a lot of facilities, especially on an obstetrics floor, everybody has to sign in and out. There are key cards. You can ask for that key card log. Sometimes we've even asked for the parking lot log to find out when someone arrived or when they left. So there's all sorts of electronic data that you can use to figure out who did what. I know there's a case that we did where it was important who was in the OR, and we found out that one of the providers actually went out through a hallway and up a stairwell and outside, right? So, I mean, there's all sorts of things that you can find out with these security logs. So really important to get those. I would say also, and this sounds somewhat nerdy, but it can be important, don't forget the bills. Detailed bills have a ton of information about what medication was given, right? Was oxygen given? They bill for everything. So if it's not on the bill, it wasn't done. So don't forget the bills for those kinds of things, but also the CPT codes. So everything, every procedure, every visit has a CPT code. If you want to know how long that doctor was in the room on an office visit, what did they bill for? What level was it, right? What CPT codes did they bill for? Did they upcode something that they shouldn't have? I mean, all that information can be so helpful in the right case. And two other little tricks for surgeons. Now, this only works for cases where people that are on Medicare might get care. But if it's, which is a lot of these cases, right? It's not little kids, but if your surgery involves people, that would be Medicare eligible, then you can look, CMS has a website. They'll show you how many procedures your doctor did of that specific procedure in the last few years and how much he got paid for doing them. So either you can find out if he's like in the top 1%, meaning he's doing a crazy amount of these, much more than anybody else, which is an issue we have in our fraud case, or the reverse. If he tries to tell you, and he or she tries to tell you in deposition, he's an expert in this, and you look it up and, he's only done 3, that could be quite helpful, right? Because, they billed for him. So it doesn't cover private insurance, but it does cover Medicare. And then the reverse is true for a learner, like a person who's in a residency. Let's say I'm a 3rd-year surgical resident and I get involved in an appendectomy and you want to know how many of those I've done. Well, guess what? The graduate education, medical education conference makes each surgeon and each resident keep track of how many procedures they've observed, participated in, and been lead. And it states which one they are on their surgical logs. So you just have to request those logs to figure out what was this person's role and how many times have they done more than just observe before. So that data is all available.
Very interesting. We talked a lot about electronic data and reports and things like that. And as I'm sure you know, sometimes even my head starts swimming when I just get a flood of data. How do you take that electronic trail and all that information and break it down so that a layman, because jury is going to be anybody in your community, it's not going to be people who are data heads or finance people, or definitely probably not healthcare providers who aren't going to understand this when you first throw it out there to them. How do you break it down in such a way that they can grasp it?
That's very important. That's a great question. And generally what we do is we'll have the medical record, and then if it's changes that have been made to the medical record, we will create a second medical record where we highlight what the changes are, and then behind that, and we're not going to show the entire audit trail is usually 800, 2,500 pages. I mean, it can be quite, and it's an Excel spreadsheet, so it's all these little lines, right? So we don't need them to see the whole audit trail. We just need them to see the provisions that are important to, as a background, like just on the side, so that they can understand that. And generally, we put up somebody from the hospital as their IT expert, and we ask those questions, and we videotape that deposition. And then we go to request for admissions and try to get them to admit those things, because what's much better is if you have admissions and actual person testimony along with it, because otherwise it's super dry. It's like looking at a tax audit, it's just awful. So you have to make it come to life through your witnesses.
Okay. Excellent.
In the last trial, I was just looking for it. You got that here. Yeah, hold on. In the last trial, we ended up just making a little bound copy of the changes. If you can see that, of the changes to the record, and we handed it out to the jury. So they could just, all they had to do was look through it, and they'd see all this yellow. That pretty much tells you the story. At that point, the record's not credible.
Got it. Yeah, I was going to ask if you had the ability.
You don't have to go into like excruciating detail for the most part.
Good. Yeah, that makes sense. And I was going to ask if you could give them a hard copy of what you just explained to them for their reference. I would think that would be really important.
Yeah, so we just send that back, and we call it the edited copy, right? And once they start seeing how many things were changed, that's enough. Like, you don't have to go farther than that. They get it. Like,
that's usually
3 days
it's a
after
smoking gun.
What you doing? And I think also you got to remember when you're trying one of these cases that you've got a jury, which, as you said, Paul, they're lay people. They're not IT experts. They're not doctors, and they're not lawyers, right? So you need to present the case on that level, right? And now with YouTube and TikTok and everything, everybody wants everything like that in a very interesting format. So you got to get to it. You can't you can't dilly dally around. They're gonna really punish you if you take too long to explain something. People just want their information precise and on point. Don't fiddle around. Right.
Makes a lot of sense.
Yeah.
Kind of shifting gears a little bit and going to, I guess, talking about some trends that are kind of ongoing or are kind of new in the field of healthcare. I know telehealth, I've used that a few times, just if I had a sniffle or whatever. And I found it to be very easy to use and helpful, but I'm sure there are downsides to it and risks associated. Tell me a little bit about what you've seen in the telehealth field.
Yeah. And I think you hit it on the head, right? For certain things in an adult, a competent adult, I think it's okay. You have a sore throat, you just want to get something from the doctor.
Right.
Maybe that's okay. But it's only as okay as the questions you're asked, right? Because I gave that example earlier about sepsis, right? So let's say, Paul, you have a fever and you have a really scratchy throat, and you just want some relief from your doctor. Okay, but what you're not going to get is a full exam.
Right.
And nobody's going to draw your blood because you're at home. And no one's going to listen to your lungs because you're at home. So, there are risks with that limited sort of telehealth visit that people have to recognize. And
Right.
what it requires is that the instructions to you need to be more specific about what you're on the lookout for, so
Okay.
that you then go to the urgent care or you then go to the emergency room.
Mhm.
Because otherwise, you're delaying getting the exam that is going to diagnose the more serious thing if you have it. Right? And it's not as good for children, and it's not as good for elderly or people that can't communicate well. So we do have to watch out for that, because it's easy and it's convenient, and you see more and more. I just saw an ad for one of the big companies around here wanting everyone to do more telehealth.
Mhm.
Okay, but it's going to
Right.
have the downsides too,
Yeah. Yeah. I've heard
The
that.
cases are challenging in that there's often not a lot of documentation.
Okay.
So they don't document the case, the record the same way. And unless it's recorded and maintained, it's hard for us to prove exactly what happened.
Right. I was going to ask, are they not recorded? Because I've done it 2 or 3 times, and they've always been a Zoom kind of. It's an app, but it's a Zoom-ish kind
Yeah.
of approach.
A
I would
lot of
assume
them
that those are
aren't.
recorded.
I think they might be recorded at the time, and I don't know what's happening in Nashville, but around here, they're not
Right.
maintained. Can you imagine the storage they would need to maintain all those?
That's true.
They don't maintain them forever. And so
Right.
you're stuck with whatever limited note this provider wrote down. And so I think that will be a challenge going forward.
Right.
And there's also licensing issues. So let's say you want to have a telehealth visit and you're in Nashville and I'm in Chicago.
Right.
Where do I need to be licensed?
Yeah.
So there's all sorts of tricky things people are working through with that too.
Yeah, because I had one telehealth thing where I was not in Nashville. But I was still in Tennessee. My doctor, of course, is in Nashville, and the first question he asked is, he goes, "Are you at home?" I said, "No, I'm not." He said, "Where are you?" I said, "I'm in Sewanee, Tennessee," and he said, "That's okay. I'm licensed in Tennessee." He was afraid I was in Kentucky or
Right,
Florida
because you
or
could be
whatever.
right
Yeah,
for work,
and
right? You could have been in Florida. I mean,
and I didn't even think about that until he asked that question.
yeah.
I mean, one question that's on this little on the slide that I'm really interested in is do insurance companies treat a telehealth med-mal case differently than a regular one?
I don't know that we have enough data yet to know
Okay.
the answer to that for sure.
Right.
I think they are going to expect less of the provider and to think that the patient understood the risk of having a telehealth visit, and I'm not sure that's fair because unless there's some disclosure like that before you start the telehealth visit, you're thinking, oh, this is okay, right? So I don't know what's going to happen with that. I would imagine they'll want to justify it because they can get paid for those televisits now.
Oh yeah.
Pretty close to the regular amount.
Yeah.
So
Yeah, I feel certain, I haven't gone back to look, but I feel certain that I signed some kind of disclaimer as I registered for my telehealth. That was basically something along the lines of what you said. Hey, this is a convenience. It's not meant for serious health issues, and we're not going to be able to take blood or do any kind of testing. So basically, it's all on you to, if you feel worse, get here, kind of thing. So,
right.
And my physician was very emphatic about, hey, this is great and saved us both a little time, but if this situation does not improve after you get your prescription in 24 to 48 hours, you need to come see me.
Yeah.
So
that sounds
anyway.
like you have a good doctor. That sounds like good advice, Paul.
I hope he is.
Yeah, it sounds like he is.
I'm still here. All right. Well,
I think, you just have to, for people that are, I think, educated and sophisticated, it might work. But for a lot of our population, that's not going to be as effective, and some people are going to fall through the cracks.
Right. I mean, this is not on our list, but I'm curious more than anything else, and it may be too early in the telehealth genesis here, but I wondered, and I've heard a lot of healthcare providers say telehealth could be helpful in that it will encourage people at least to talk to a doctor rather than wait until something gets so bad and go to the ER.
Yeah, I mean, I think that's an interesting idea. And we're right. I think we don't have enough data to say whether
Right.
that's true or not. I think one thing that it's very positive for is what I would call a teleconsult. So provider to provider.
Oh,
Let's
yeah.
say you're in the middle of Alaska and you've got a pregnant patient that's having like a really weird complication, right?
Right.
Having teleconsults where you can get on with a maternal fetal medicine expert who does high risk pregnancy and figure out how to help that woman, that's wonderful, you know?
Yes.
Or you've got a brain scan and you're in some little town, you know, in Tennessee, and you don't have a neurosurgeon in town,
Right.
you get one on the phone and you can get one to look at that image. That's where I think the technology is awesome, you know,
Yeah.
and that's really helpful, and that makes it better as opposed to this where I'm concerned that people are going to fall through the cracks.
Right. I get it. Okay. Let's see. I guess a couple of other, I don't know if it's trends, but tell us what you've seen as far as developments with informed consent.
So that's what we were talking about a little bit earlier, and people just should remember that informed consent is not that little form you sign. You know, if they have you sign a form, that's fine, but the dialogue is the important part, and it's an ongoing dialogue. So you have a serious condition and you're treating for, you know, a year, then that consent dialogue, that shared decision making is going to be part of every communication you have. And we talked about telemedicine, but one of the other things that's happening is people have patient portals now. I don't know if you have a patient portal.
I was going to ask about that. Yes, well, yes, my physician group does.
Yes. So some systems are set up and encourage patients not to call, but to email in through the patient portal their complaints. All right. So now we're not even seeing, right? The provider isn't even seeing you. They're relying on your typing skills. You know, which they're not even asking you questions. It's a one-way in, right? And timing and who's that going to and who's triaging that. I mean, those are all huge systems issues. We're involved in a case right now where that's a huge issue. So I think that part of the communication is really fraught with what could be disaster from the patient's point of view. And if you're told to tell them your symptoms that way, well, who's answering that? Who's looking at it? Does the patient know that some symptoms are an emergency? Like, how's the patient supposed to know that, right? You know, my baby has 104 temperature. Is that something I should email the pediatrician about? No, I should be at the emergency room right now, right? And so, you know, if it's your first kid, you're not going to know. If they're throwing up, they're not wetting a diaper. That's a really big deal. They're dehydrated. They need to be seen. You might not know that, you know? So I just think that's really an area where it could be a concern and where we're going to see, unfortunately, things fall through the cracks. And I think people don't type as much. Patients don't type as much as they say. And providers don't answer and give you the details that they should, right? Because who's going to sit there and type everything?
And I think the patient portal that I've had is at least not one where they're asking me to send my symptoms in. It's handy to schedule an appointment. It's handy to get your lab results back. All those kind of things where it's, you know, HIPAA, they can't email them to you. You know, and they can fax them to you, which I still find odd. They can fax them, but they can't email them.
Actually, with your consent, they can. I don't know why they tell you.
Okay. Anyway, but now I get all that.
I think they don't want to get into emailing everybody stuff.
Yeah, but at least now I can get them electronically. They put them on the portal. I get an email say, hey, you got something on the portal. That I find to be very helpful. But I can see where you're coming from, where if they're not even laying eyes on you virtually even, and all you're doing is saying, hey, I've got a sore throat and a 100-degree fever, what do I do? And they're just like, hey, we'll call you in some erythromycin. Go pick it up. kind of thing.
Yeah,
That we may be missing something. All right, I got a question here from somebody in our audience, and it's this: would you be willing to share subpoena or discovery language that you use when requesting metadata and audit trails?
yes, so we have a standard request, and is my email on here somewhere? If you send me an email.
Yeah, your contact information will be at the end here. So
whoever that is, if you just send me an email, we'll send you the question to ask.
Great, thank you.
My partner is like the audit trail guru, so.
Good. Let's see. Looking here. Tell me.
Let me just tell you, when you're making that request, the key thing is to make sure they give it to you in a searchable format. You want it in an Excel spreadsheet. That's, to tell you the truth, the most important thing. But a lot of times they won't give you the whole audit trail. So just send me an email and I'll send you the request we use.
Great, thank you. And then I guess another question is, delve a little bit into, I know we touched on a little bit about surgeon fraud. Tell me a little bit more about, a case that you've had about that, or so what that really means.
So it's either doing surgery that the patient doesn't need to have done, or saying that you've done certain procedures during the surgery just to get paid more when you actually haven't done those. And in our case, our recent case, we had evidence of both. So he was doing, he was a vascular surgeon, and the jury determined he was doing unnecessary surgery on our patient because he told her she had all these problems. So he did a bunch of surgeries and procedures and billed like excessive amounts. He also, when he was in her arteries doing a procedure, he then listed a whole bunch of other things that he did when he was in there that were both unnecessary. And our vascular surgeon from Harvard said, I don't think he did any of this. So so it can be unnecessary surgeries, or it can be billing for surgeries that were not done. So it can go either way.
Wow. And so many of these issues that we talk about seem to come down to healthcare as a profitable venture, rather than healthcare as the healthcare of an individual. So anyway.
What we did in that case is profits over patient safety.
Yes,
right. Is the doctor there to do what's right for you, or is the doctor there to line his or her pocket? That's the question.
And again, I have no issue at all with healthcare being profitable. That's fine. Everybody, lawyers perform an important service, but they need to be profitable. Otherwise, they're not going to be doing it for very long. So I think physicians and hospitals and all that kind of stuff have to charge for their services. But you're right. The care of the individual has got to come first.
The thing that I think is harder in healthcare is, if I go to I can drive by 6 gas stations and see what the price of gas is.
Right.
I can make the choice, right? We try doing that with your hospital or your surgeon bill. You just can't do that. They don't have the same transparency. So listen, 99.9% of providers are awesome. They're wonderful, and they're not doing any of these things. But the people that we're talking about are in a system where they can overcharge and they can do things. I mean, how do you know if your veins and arteries are okay? You have no idea, right? Some vascular surgeon who's triple boarded tells you, you better get this surgery, you're going to lose your leg. You're going to do the surgery.
You're going to do it. Yeah. Right.
You're asleep. Did he do it? Did he not do it? How do you know? You don't know.
Yeah. By the time you get up, it's already closed up and stitched. You have no idea.
Yeah. He's like, went great. Okay, good.
Yep.
Yeah, you don't know.
Well, Katie, thank you so much for joining us. And for those who are interested, here is Katie's contact information, Katie at blg-dc.com.
There you go. Now, I start a trial on Monday, so I'll try to send it to you, but don't be a little patient with me.
Understood. So bear with her, but there's her contact information.
And I can get it to Paul too. So I'll get it to Paul. So for all of you who have representatives who are awesome at Advocate Capital, I'll get them the interrogatory too. So there's
that'd be
two ways. Request for production is really
So
what
you
it is.
can
And that
shoot
way
me an
there's two
email
ways.
at some point soon, and I'll have it as well. So, but Katie, thank you for taking the time to do this. I hope our audience enjoyed it. Again, there's our information. If you ever want to see any of our other webinars, you can see the information at the bottom. And again, you don't have to remember all this stuff. We're going to send all this out to everybody with the links. You can go back and review everything. If you have any questions, you can reach out to me directly. I'd be happy to help in any way I can. So, Katie, again, thank you for your time. Have a wonderful day and good luck in your trial that you start on Monday.
Thanks to everybody who's helping victims, and thanks also to Advocate Capital, because they've been truly tremendous help to me too, and I'm sure everybody thinks the same. So thank you.
Thank you, Katie. You're kind to say that. We're always happy to have you guys, have you as a client, and all of our other law firm clients across the country. So thanks again, everybody. Have a wonderful day, and we'll talk to you soon.